This is Professor Nora Freeman Engstrom from Stanford Law School in California to discuss United States versus Carroll Towing Company. Welcome, Professor Engstrom.
Well,
or is it Freeman Engstrom?
Engstrom is fine, but I answer to anything. And I'm so delighted to talk about one of my favorite cases, United States versus Carroll Towing. In this case, Judge Learned Hand sets forth what is now known as the Hand formula. The formula is not unassailable, as I'll address, but it is extremely important in making sense of what does or does not constitute negligence. Negligence, of course, is the backbone of the tort system in the United States today. So first, I'll say a word about the accident that gave rise to the case. Then I'll say a bit about Judge Hand, the author of the opinion and a real giant in American law. And then I'll offer a little bit about the opinion and a brief critique of the Hand formula. So like so many other famous opinions, United States versus Carroll Towing arose out of pretty mundane facts. So in the case, plaintiff Connors owned a barge, the Anna C. And in January 4th, 1944, the barge was in the New York harbor. Now, if you can think about history for a moment, you will quickly realize that 1944 was a very busy year for the United States in general, and the New York harbor in particular. We were in the grip of war. Indeed, D-Day, June 6, 1944, was soon to come. So the New York harbor was very busy, a hive of activity, as this photo from the period depicts. And the opinion talks about it too. Here's another aerial view of the New York harbor that exact year. And in the opinion, Judge Hand talks about the fact that New York harbor was in a full tide of war activity where barges were being constantly drilled in and out. So in this case, the defendant, Carroll Towing, had tugs. Here's another photo of tugs owned by Carroll Towing around that time. And it negligently readjusted the lines of the Anna C while getting their tugboat past it. After that happened, the Anna C broke free. It collided with a tanker and it sank. Litigation following that accident ensued. And here the case involved the United States because the Anna C was carrying cargo owned by the United States, actually $10,000 worth of flour bound for Europe. Now, the issue in the case was not one of defendant's negligence. It was really focused on plaintiff's negligence. So the defendant insisted that if our bargee had been aboard the Anna C at the time when it was set loose, the bargee could have sounded a warning, and other boats, through siphoning efforts, could have kept the Anna C afloat. So this whole problem could have been averted, defendant said, if that bargee had been aboard the Anna C at the appropriate time. So eyes on plaintiff's negligence. Case went to trial. It was an admiralty case, so there wasn't a jury, it was just a judge. The judge found no negligence on the part of the bargee, on the part of the plaintiff, so did not reduce plaintiff's recovery. At that time, actually, even in admiralty cases, plaintiff's recovery would have been reduced through comparative fault principles. But here, no negligence. That's bad for the defendant, Carroll Towing, and Carroll Towing appeals that finding. So again, the issue in the case was whether plaintiff's negligence in not having a bargee on board the Anna C should reduce its recovery under comparative negligence. So it gets to the Second Circuit, and in the panel of the Second Circuit, the parties encountered Judge Learned Hand. Learned Hand served on the Second Circuit Court of Appeals for some 50 years. And he is a giant in American law. So here actually was the New York Times celebrating his 50th year on the bench. And it's rare to see anything written so nicely about anyone these days. The New York Times hails him unquestionably first among American judges. Notes more than anything else, Judge Hand symbolizes a method that judges endless striving for truth by means as dispassionate and as dedicated as man can achieve. And through the hundreds, perhaps thousands of cases Judge Hand decided over his many years, his decades on the bench, this case is arguably the most famous. And what makes this case so important? It's not the facts. It's not the fact we lost some flour. It's not because whether or not it's really important whether or not you have a bargee on board at a particular time in the full tide of war activity. What's so important about the case is contained right here in this paragraph. Hand writes, the owner's duty, as in other similar situations, to provide against resulting injuries is a function of three variables. One, the probability that she will break away. Here, the probability that the bad thing is going to happen. The gravity of the resulting injury if she does. The gravity of the resulting injury if the bad thing happens. Three, the burden of adequate precautions. And he knows this is what made him famous. Possibly it serves to bring this notion into relief to state it in algebraic terms. If the probability to be called P, the injury L, and the burden B, liability depends upon whether B is less than L multiplied by P, i.e. whether B is less than PL. Here's how I teach it. If the burden is really hard to do, and it's a bigger burden than the resulting likely injuries, not to take that burden is reasonable care. If it's the other way, not to take that burden, not to take those precautions, here that would be negligence. Again, with P being probability of harm, L is the magnitude of loss, and B, burden of precautions. So Learned Hand took a concept which had been in the air forever, and he defined it in a somewhat new way. So the Hand formula attempts to give content to that traditional but vague notion of what is reasonable care, the failure to do what a reasonably prudent person wouldn't do under the circumstances being negligence. Okay, and here again in this case, the probability of harm was high because recall these were no tranquil seas. It was a busy harbor in the high tide of a full tide of war activity. We're dealing with cargo, we're dealing with really expensive boats. And the B, the untaken precautions here, that was low, as having a bargee on board during daytime hours. Not so hard. The court even goes out of its way to say if this were the middle of the night, maybe different circumstances would obtain, but here what we're talking about is the burden would not be so high. So here in this case, the failure to have a bargee on board, the court says, well, that's negligence. The burden would be small. LP, the probability of harm and magnitude of loss would be large. So that's the Hand formula. Now I said critiques. Who could critique such a thing? Well, it turns out a lot of people. So critics of the Hand formula raise various concerns. Here are just three of them. First, a lot of people point out that you can't give a mathematical equation to what is or is not reasonable. And that's partly because there's a moral intuition that life and limb are incommensurable. You can't measure them the same way you can measure some flour. It works with flour, but it doesn't work with a child's eyesight. It doesn't work with a person's arm, a person's leg. So moral intuition that life and limb are incommensurable. We can't or shouldn't monetize these things. And that's what the Hand formula asks us to do. Second, many believe that negligence requires reasonable, not merely economically rational behavior. You shouldn't be able to hurt people just because doing so is good for your bottom line. And finally, the Hand problem has very serious practical problems. Information on P, B, and L is often available, or it is inaccurate. And when that information is missing or it is inaccurate, judgments will be wrong. Actors who fail to take cost-justified precautions will often be held liable, and while actors who fail to take cost-justified precautions will often be held liable, and while actors who the other way may be escaping liability. And here, interestingly, Judge Hand recognized this. So in a subsequent opinion, he perhaps offered the fullest critique of the Hand formula itself. So in this portion of an opinion which came later, he notes that care is the only one ever susceptible to quantitative estimate, and often it is not. So noting this is the B, the burden of untaken precautions. It's the only one, he says, that you can actually put a number on, and often you can't do it. Although probability might theoretically be estimated if any statistics are available, they never are. And he comes down to say all such attempts are illusory, in his own words. So the Hand formula has its critics, including Judge Hand himself, in a very reflective further opinion. But the formula, in the case from which it comes, is a key pillar in the American tort law canon.
Excellent. Thank you very much, Professor Engstrom. It helps us understand why this case is such an important precedent. It articulates that formula, which at least gives a jumping off point for an evaluation of whether conduct is negligent or not, and whether the actor should be held liable or not. Very good. Thank you again for participating with us. I really appreciate it.
Well, thank you.
Excellent. Thank you.